hypothetically, and I love it. That's what we want to do here. I create a business and I call my business name my last name. Can I technically trademark it? Like
No,
Disney, Hershey? What?
no, you can't. Here's what I'll say about it. So one of the bars to trademark registration with the United States Patent Trademark Office is the surname refusal. So generally speaking, the rule is that we are not allowed to register our last names as trademarks because it would be unfair to all the other Hubners and Kulsas of the world if we had the exclusive rights to use that for any given type of service. That said, you can get around the surname refusal if you've become distinctive in the marketplace, despite the fact that your last name is a surname, right? So if you've been around for more than 5 years and you've garnered a reasonable amount of attention, then you could potentially claim acquired distinctiveness or secondary meaning and get around it. But generally speaking, the answer is no. We can't register a surname.
Got it. So, what are the main challenges Asian companies face when enforcing patents internationally? I thought this was interesting when I first read it, and now I'm reading it out loud. Okay, Asian companies. And let's see. I'm not sure, what that means. I mean, Asian-owned companies that exist in Asia. Maybe that's a huge part of the world. Let's just say China. Let's just say a company that is a Chinese company. What challenges do they face when enforcing patents internationally? So if you are a Chinese company and you're selling, let's say in the US, what's a challenge that you might have that differentiate? I don't know. I really can't think right now on my feet in terms of what additional or what barriers they would have as opposed to anyone else trying to sell in that direction. You're gonna likely have to have, just so you all know, there are different patent laws on the books at each country. And so whether you're seeking patent rights or enforcing patent rights, you'll need to work with local counsel. Each country will have their own patent bar. And here in the US, that's what Bold Patents is. We help represent inventors that want to get or enforce patents in the US. So you'll need to hire a firm in the US to go enforce. Quickly, not answering too much, I don't want to go too much longer on this, but if you're, let's say, a US company and you're selling in Asia, kind of the reverse of this question, you're now kind of, maybe at the burden, maybe this gets to the answer. And the question is, you're dealing with a different system. You now have to go learn about the enforcement mechanisms in those countries. And some are going to be more strict, some will be more lenient. It really is up to how they want to run their system and govern it. And so I would assume penalty, damages, right? How you can pursue licensing agreements, how enforcement's going to happen, whether, restraining orders are going to work, how customs work in those different countries. A whole host of different things come to mind. Matt, would you add anything on top of that?
No, not in particular, JD. I think you covered it. So I saw this hit my newsfeed the other day, but the USPTO 3 days ago, let's see here, issued a show cause order to cancel more than 40,000 Chinese trademark registrations. So we've been 40,000.
40,000.
Yeah, it's a lot of trademarks. So for those who've been following along at home, USPTO is way behind in terms of their trademark issuance and registration timelines. Part of the reason for that is the amount of Chinese trademarks here in the United States. The Chinese government for a long time was dumping or paying their companies to file trademarks in the United States. Apparently, a lot of those trademarks ran through this one Chinese company, or don't quote me on this, but one company called the Cellular Growth Network Technology. And apparently, allegedly, they were basically filing trademarks for Chinese companies here in the United States using American attorneys' names. But those attorneys really weren't operating as attorney of record for the trade act. So what's been happening recently for the listeners is we've seen a lot of paralegal firms outside the United States trying to get into the United States by having, attorneys here in the United States co-sign their applications as a way of getting around the new rules that the United States, in order to have a trademark application here, you have to be represented by U.S. counsel if you're a foreign entity.
You have to have a U.S. attorney somewhere.
Yep. If you're a foreign national or a foreign entity.
Yep. Okay.
Wow. And we've seen a lot of attorneys get in trouble recently with filing these Chinese trademarks without really even looking them over, right? They're just co-signing these applications. Seen some attorneys, I think suspended for practice in front of the USPTO or potentially discards.
Yeah. Well, I guess that's generally good news, I think.
It's great news.
I don't see any downside to that. So I developed a new technique to solve a specific problem in an electronic system. During my PhD studies at a U.S. university in Vaganov, the work was presented at I'm sure the word is refereed conference, and became available and accessible in their proceedings. This person did not file anything at the time, but 1 year later, a very big corporate filed a patent with the exact same technique he invented.
Oh, you're going to get in the weeds here, aren't you? On the other time.
I'm going to dive in just a bit. So, yeah, go get him, David. And it's just like, heck yeah. And I assume being a PhD, you've got some documentation. You can provide some sort of affidavit, some concrete evidence of this transfer of knowledge. And so there's a couple different ways to go. There is the good old federal court system. There's also mediation arbitration to change inventorship. And that could be an approach. You work with a patent litigator and you threaten a whole other thing about you defrauded the patent office. You derive this invention from my client. If you don't change it, we will go after the attorney, go after the inventor for defrauding. It seems like what happened, if this is true, if when you file a patent application, you have to sign and swear an oath saying that you are the inventor. Seems kind of basic. And if that was done with knowledge that they did not, in fact, invent, that is pure fraud on the patent office. So that is a great, I think, ammunition to get a nice settlement and to get things done from traditional litigation. There is a new avenue, relatively new. Within the past 10 years, the PTAB created a derivation proceeding, which is pretty cool. It does come with a 1 year timeline. So you have to go to catch them 1 year or less from when they filed it. So it's pretty tricky timeline-wise, but you can file this proceeding. And the other catch is you have to file an application and say, yeah, okay, I got rejected by these guys, but they stole it from me. And that's how this petition works. So there's definitely a couple different avenues to go down here. And if you'd like to, we'd be honored to help you work through that. So pretty cool. There is justice, even against those very big corporate folks. So let's go back to the trademark side.
Hey, JD, quick question for you. When it comes to patent litigation, do most patent litigators take work on contingent fee? Or I guess it really depends, I would think, right? Maybe they do a kind of a hybrid where they do an initial payment for the initial lawsuit and then a contingent after that.
Yeah, we work with one in particular that does offer contingent representation, but there is this sort of initial chunk of analysis that is required. It's called claim charting, where you really dive into each element of your claim and look at the accused product or the accused infringer and say, is there, analysis to say, yes, each element of the claim is met. And if it looks thumbs up, there's a couple different routes to go on the contingency side, where you go after financing, or if you just proceed with a bit more of a risky approach and the attorneys want to take it on. So yeah, your case, they'll be lined up to help you. Okay. Another simple one, but I think it's good. It's one that comes up a lot. I don't think we've answered here, at least in a while. Is it possible to trademark a political slogan or a jingle? If so, what's the process for doing that?
Yeah, you certainly could if it's yours, right? If it's somebody else's slogan or jingle, of course not. You can't. But yeah. I mean, all things sold, bought, proffered fall into one of those 45 categories at the USPTO. So I have to think about what this would be. Maybe education class, because you're doing some advertising, promotion, education potentially. I don't know. That's interesting. I've never worked with a political group on a political application like this. So
how about the other side? And let's take an extreme example and go, musical only, a tonal mark. 7 tones in a row.
Untraditional trademark.
Yeah, is that feasible? Can you actually apply?
Yeah, you can. So there are things called sound marks. They're extremely rare, but I'm thinking like back to law school, right? I think the example was like the NBC tones, do, whatever it is, like something like way off. But, those have become distinctive enough that, they're registrable as trademarks. But a barred registration for sound marks, smell marks, olfactory marks, it's extremely high. So you're talking, you're gonna have to bring in expert testimony. You're gonna have to conduct some surveys. You have to bring an expert to discuss the survey to prove that your mark is distinctive.
Oh, that's great. Got it.
Yeah.
Got it. Not gonna be,
but yeah,
not
you
a
can.
word mark.
But I would say, you're probably looking at least 20 grand. I would think, between experts and all the research and surveys that are required to even consider registering one of these.
Cool. Yeah. Probably one of those ones where you've been in business and done very, very well, and you want to just continue protecting your brand. And this is not the first thing you're going to do.
No, this is moonshot for sure type of trademark application.